Hey y'all, Gary with Tennessee Stands. Hey, look, I mean, I'm literally having a meeting right now with the man who, David Fowler, who's worked with the Family Action Council here in Tennessee for, I don't know, 14, 15,
years.
16 years. Wow. And David is someone in Tennessee who has been working on abortion legislation in terms of constitutional amendments, things that are currently in law. And as we're meeting, just so happens, literally, I mean, just now, the Supreme Court of the United States overturned Roe v. Wade. And here's Mr. Fowler. So I wanted to give him an opportunity to speak to you about what that means for Tennessee. This is quite huge. And overturning Roe v. Wade does not mean the same thing for every state in terms of their current laws. We didn't just make abortion illegal in the United States. So I'll let the guy who knows more about that tell you why.
Yeah. Well, thank you, Gary. And it's good to be with you this morning. I make it a habit to meet with candidates, and of course, I've known you for a while, but still, that's part of my job, meet the candidates. And This morning, we were going to meet and talk over some of the things of interest to our organization, and out comes the decision. And one, we ought to rejoice. I mean, you can't but be happy that Roe versus Wade and its progeny has been reversed, but not just for the pro-life community. This is for all people who believe in a constitution whose words have meaning.
Yeah.
A constitution whose words have meaning because they're rooted in history and in the common law, things that you and I talked about so much when we used to do our podcast together. And also, it's a great victory against the doctrine of stare decisis and judicial supremacy that has held conservatives at bay, of their own choosing, of course, for 48 years, and in so many regards. We act as if the Supreme Court makes law. We act as if the Supreme Court writes the Constitution for everybody when it issues a holding resolving a law dispute between two different people. But the real role of the judiciary is to say in a lawsuit between Gary Humble and the state of Tennessee, or Gary Humble and the state of Mississippi, if that's where the law is, all they're doing is saying, should Gary win or the state of Mississippi win? Has nothing to do with whether Bob or Fred or Julie or Sam in Ohio or Tennessee or Kentucky should win. They don't have jurisdiction to make laws. They don't have jurisdiction to decide anything except for who wins in the courtroom.
Yep.
So everybody that cares about a limited judicial power that allows representative government to work should rejoice in this opinion, even if they're not really pro-life and the particular issue doesn't care. This is a win for the Constitution.
Well, we've got a judicial supremacy issue here, and the question that we continue to ask ourselves, do we really believe that courts make laws? But it's beyond that a little bit. It's a states' rights issue as well.
Well, it is. It ought not be a states' rights issue, which goes back to the Dred Scott case.
Okay.
And for those who don't remember, Dred Scott was a slave, or an ancestor of a slave. And prior to the Civil War, the question was whether he could be a citizen of the United States and sue in federal court. The Supreme Court said, they would have never intended, and these were their words, an inferior and insubordinate being to rise to the high level of a citizen. So you can't sue in the courts. Well, it led to a little war we call the Civil War, the War of Rebellion, as some people call it. But what's happened with the Supreme Court today, as much as we want to rejoice that this subterfuge of misunderstanding of the history of the common law as it relates to the treatment of abortion, the court did not look at the common law and the fact that it treats the unborn as persons. So there's a sense in which what the Supreme Court did is worse than Dred Scott. Dred Scott would have still been considered a person under the 14th Amendment. He would have been considered a person under the Due Process Clause of the 5th Amendment. In fact, the African Americans were counted as persons towards apportionment, not for a full vote. They didn't count 1-to-1, but they were still persons for that word in the Constitution. The unborn aren't even persons. So they're not citizens, they're not persons.
So the point being, if we were
worse off, if we were consistent with what we believed, we would say all human beings who have life that comes from God are persons. Instead, we're allowing states to decide whether you're a person.
That's a great point. So if we were appropriately interpreting the Constitution would protect the life, liberty, and property of all persons, including the unborn. Right. It would not be a state's issue.
That's right.
Okay.
And the common law is there. We've written briefs on it. Our organization, Jeff Schaefer, Adam McLeod, who you know, we've written briefs on it. John Finch has written a brief on it. I'm urging states now to say, defend your laws based on the 9th, 10th, and 14th Amendment.
Unfortunately, though, right now, the way that interpretation is understood, it's primarily going to be treated as a state function.
Right, but only because we still have never asked the court, are the unborn persons at the common law? And I explained, I was on a podcast the other day with some friends, and I said, it's kind of like this. My wife and I dated for 5 years off and on before we got married. And she could have been asking me all that time, do you love me? Oh, yeah, sweetie, I love you. Do you want to spend your life with me? Yeah, sweetie, I want to spend my life with you. And finally, after 5 years, she could have looked at me and she said, are you ever going to ask me to marry you? And I said, oh, no, I'm never going to do that. But you told me for the last several years you loved me, that you want to spend your life with me. There was nobody more important than me to you. And I said, and that's right. I just don't want to marry you. and so the pro-life community for 48 years has been afraid of saying, does the common law, the history of the common law behind the word person, treat the unborn as persons under the law? The answer is clearly yes. Even Roe said, we acknowledge that the unborn are treated as persons for purposes of property. Now, I was an estate planner. I knew that if there was an inheritance issue because of, for instance, your death, if your wife was pregnant, somebody had to represent your child in the womb. So what the Supreme Court has failed to do, as much as we rejoice that this subterfuge has been reversed, they stop short
of fully protecting persons per the United States Constitution.
Yeah. It's sort of like saying, I believe in God, but now I don't want to believe I'm a sinner.
So I want to close with this. What does that mean right now, today, for Tennessee? You were directly involved in a constitutional amendment and a trigger bill that we currently have in state law. So constitutionally, I think it's Article 1.
We're good.
Yeah, there's no right. You have no right to an abortion in the state of Tennessee.
Under the state constitution. Now, what's been happening with me is I've been consulting with other states like Iowa and Kansas and some others because they thought we need to pass amendments because they'll go to their state Supreme Court and get Roe versus Wade put into their state constitution. That's what happened to Tennessee. That's what I took out. I led the.
We've already fixed that.
We've already fixed that. And we've passed a trigger law.
Now speak to the trigger bill,
Yeah, the trigger law says that as soon as Roe is reversed or altered in any way, the Attorney General will inform the Code Commission, who publishes the Tennessee Code, that there's been a change, and that will trigger then what I would call a fetal life bill, or what you and I called back when we were working on it, the Rule of Law Life Act, so that essentially, except for the life of the woman, doctors can't perform abortions.
So what is that protection right now per our law, per that trigger bill? Is it what's the detection of life? It's not is it a heartbeat, or
it just says pregnancy?
So if the mother is known to be pregnant, period,
doctor can't do an abortion.
Okay. So I want to be clear. Mm-hmm. As of the Supreme Court decision today, because of the trigger bill that's passed, abortions are illegal in the state of Tennessee immediately, right now. Today. Is that the way the trigger bill will work?
It doesn't work.
What's the process?
Until the Attorney General sends a notice to the Code Commission.
Okay. How long do you think he might have to do that?
Well, if it had been gay marriage, the Attorney General would have said today.
Yeah.
But technically.
Like he did in 2015.
Yeah. But technically, there's an opportunity, a time period, where that parties could ask the court to re-review the decision. We think you made something fundamentally wrong. So technically, the decision isn't final until an order goes down.
Hang on. Currently, the Supreme Court decision that we're hearing about right now is not absolutely final. It can still be reviewed.
Yes, it could be like it's a motion for reconsideration, essentially. And I filed some of those in some of our lawsuits. I said, I think you got it wrong. I want you to reconsider.
We should expect that to happen, right? In this case?
I don't know. Of course, we didn't do it on the gay marriage cases, but that's because conservatives don't care about marriage. The pro-aborts care about abortion. They may. Mm-hmm. But my point is, actually, the court they've issued an opinion, and it says it's so ordered. The clerk then prepares an order.
They haven't issued the order yet.
That's right. Okay. And the order is what the court officially acts by. That's why they can't write laws. The only thing officially they have to do is enter an order saying who wins.
So at the order, then our Attorney General has a duty to communicate this to codes. And
Yes, right.
okay.
Yeah. So, like I said,
You see, this is why David Fowler is here talking about this. So you getting the truth.
Yeah,
really.
yeah. So anyway, as I said, we didn't do that when gay marriage came out. We didn't wait. We didn't ask for motion to reconsider. We didn't say, "Hey, Ruth Bader Ginsburg already said."
We just did it. We changed our form. We did everything.
Yeah, Governor Haslam started changing the forms without the legislature. The whole ball of wax. But I don't know when our Attorney General will do that.
Well, here's the thing. What we know right now is...
But that's what we will have.
Yeah. It seems like Roe v. Wade is overturned. It seems like our Constitution now is sound and actually is going to be effective.
Yes, that's right.
Wow.
Right.
That's incredible.
Yeah, I started on that in 2001.
Yeah.
So, yay.
And the trigger... And thank you. Yeah. I mean, because so many of us in Tennessee know that a lot of what we're going to see the fruit of now has been through your labor over years and years of work, not only as a state senator, but running the Family Action Council. So thank you.
You're welcome. I was just glad God put me in a place to do it.
Yeah. Thank you all. Appreciate it. Rejoice, celebrate. It's a great day.
And get back to work helping other states.